Ladies and gentlemen, now I come to the next point, that is nature and scope of the best interest or welfare theory in case of custody dispute. The literal meaning of the hijanat is upbringing. In the legal terminology, the upbringing of a minor child by the mother some uh, by someone legally entitled to it is called as hijanat. Also, because under Muslim law, the word hijanat has been used instead of custody, and under the other legal system, word custody has been used. So, the literal meaning of the hijanat or custody is a rearing or upbringing or helping the child for his or her proper growth. In legal terminology, the upbringing of the minor child by the mother or by someone legally entitled to it is called as hijanat or custody. There is a consensus of opinion among the companions of the Prophet of Islam on the point that in first instance, mother is entitled to the custody of the child. And there are reasons. And the reasons behind this rule is very rational, very logical reason. And the more sociological aspect or sociological reason is also inclusive in this policy of the law that mother is should be the guardian or should be entitled to the custody of the child. And after the mother, the entitlement of the relatives comes. There is, however, difference on the point that up to what age of her son or daughter is mother entitled to the custody. According to the Hanafi law, and that is the founder of Hanafi school, Imam Abu Hanifa, the mother's right of the custody of minor goes in the following order. Whereas there is a difference of the opinion among the other schools. Hanafi school, Safi school, Maliki school, and Hanbali school. On the basis of the interpretation of the fundamental sources of the Muslim law, the founder of the different school have arrived on the different conclusions so far as the a minority of a child with respect to his or her custody is concerned. But since in India, Hanafi law is the law of the land, therefore here I am making the reference only of the Hanafi law that according to the Hanafi law, up to what age a mother is entitled to the custody of the child. Rule is that in case of male child, the mother will be entitled to his custody till she approaches to the 7 years age. And in case the child is female, she also she can also be the child shall be treated to have attained the age of majority when she attains the age of puberty, means she is the grown up. In Shia law, a male child till the 2 years and a female child till the 7 years is considered as minor, and up to this stage he is capable of being given in marriage. Ladies and gentlemen, since the Holy Quran is the fundamental source of Muslim law, and the Muslim law basically derives its sanctity first from this source, that is the Holy Quran. But in Holy Quran there is no verse specifically providing for the right of the custody of the mother. However, the Jews, by way of seeking Quranic sanction, deduce it from the verse relating to the fosterage. God says, the mother shall give the suck to their offspring for 2 whole years if the father desires to complete the term. This directive is for those who want to benefit from the complete term of the fosterage. Hence, from this verse, the Quranic sanction is more or less obvious that the right of the custody is first belong to the mother. Uh, the second source of the Muslim law is the tradition or saying of the Holy Prophet. Beside arguing from the above Quranic verse regarding the mother's right of the custody, the Jews rely upon number of the incidents and tradition as under. When the Holy Prophet, peace be upon him, came out among the people after conquest of the Makkah, this is reported in the book of the Hadith. The daughter of Hamza followed him and called out, O uncle, O uncle. Thereupon Ali caught and hold Fatima. Take care of your hold. Take care. Take care of your old uh, of and her uncle's daughter. Consequently, the aunt took her. A dispute arose between the Ali and Zaid and Jafar on this account. And ultimately, the one who is the nearest in relation from the female side was given the custody of the minor child. And in this way, it is well established that the best entitled person to the custody of the child under Muslim law is only and only the mother. And this rule has been given the legal status in various countries, Muslim countries. Therefore, relevant laws on the hizanat or custody enacted in the several Muslim countries are given here one by one for the ready reference of the learners. Friends, in Egypt, Section 20, and according to Section 20, a Qazi is competent to permit a woman for continuance of her custody. In case of a boy, after 7 years till the age of 9 years, and in case of girl, after 9 years till the age of 11 years, when their interests so demand. So this is the real rule position regarding the custody that in Egypt, a Qazi means a magistrate. Qazi is the magistrate. So in Egypt, under Section 20, a Qazi is competent to permit a woman for continuance of her custody in case of a boy after 7 years, or 7 years till the age of 9 years, and in case of girl after 9 years till the age of 11 years when their interests so demand. Means in Egypt, in ordinary course of the circumstances, of course, mother is entitled to the custody of the child up to 7 years or up to 9 years or up to age of puberty or till the remarriage or till the marriage, as the case may be. But after prescribed age, mother, normally the mother will not be the lawful guardian. But after 9 years till the age of 11 years, when their interest is so demand, that is the mother will be, father will be the lawful guardian of the minors. But if the interest of the child is protected under the care of the mother, then the custody can be retained with the mother. In Tunisia, Section 60, it is incumbent upon the father as well as other guardians that they take the due care of the one under their custody and send him for study and the educational institution. However, if in the given circumstances it appears that the person given the custody of the child is not taken care of, he can be deprived of it and the child can be restored to the original father or mother as the case may be. Section 62 further provides that as long as the mother's custody continues and interest of the minor under the custody is not in conflict with her own interest, the father shall be forbidden to take the child out of the city where mother resides except when mother consented to it. So again picture is clear that where the child is in the care and custody of the mother and his interest is safe, then mother can continue the child custody over the child even after the expiry of the fixed period, that may be 5 years or that may be 7 years. Section 63 of the Tunisian law says, if a family law says that if a woman without any physical disability transfers her custody right without consent of the guardian wali to someone else, such transfer shall not be valid, and the woman, however, can forego her right of custody. Section 64, it is permissible for the person entitled to the right of custody to surrender such right. The right shall then get transferred to the person who comes next to him in degree as mentioned in section 57. But if the person named in the section 57 refuses to accept the custody or any other person entitled to the right of custody be not present, he shall then not be entitled to the surrender his rights of custody. Section 65, the women having the custody will not be entitled to any remuneration for custody except compensation for services rendered to the child. For example, cooking food for child and rendering the other services to whom according to the uses. Section 66. If the child lives either with his father or his mother, it shall not be forbidden for the other to meet him. The one who wishes to take the child for a visit shall do so at his own risk and cost. Section 67 says that it is a fixed rule that minor before attaining the majority shall remain in the custody of the female guardian in case of a boy to 7 years and in case of a girl to 9 years age. Thereafter, if the father wishes to obtain the custody, it shall be so ordered unless the court finds anything which makes it necessary for continuation of the custody of the child with the women. Jordan is another Islamic country. There is law on the custody and the guardianship of the child. According to the law in Jordan, when a minor boy completes the 7 years of his age, his custody period with his mother shall end. In case of the girl, when she completes the 9 years, it shall, however, be lawful for the Qazi to permit the women in case of boy to keep him in custody from 7 years to 9 years of his age, and in case of the girl from 9 years to 11 years of her age, when it becomes apparent to the Qazi that their interests so differ. So the rule is same. That the standard rule is that mother is entitled to the custody up to 7 years in the case of the boy, up to 9 years in case of the girl. But on the expiry of this specified period, on the application or the request of the women, the court may permit the such women to continue with the custody and guardianship of the child, because welfare of the child in the given circumstance lies with the mother. So on the ground of the welfare of the child, such rules are there, and the court can take decision in the light of these rules. In Syria, ladies and gentlemen, in Syria, section 142. The liability of payment of remuneration for custody is that of the person who is responsible for maintenance of life. The remuneration shall not be more than half of the maintenance charge of because when the child is up to certain age, custody will be with the mother, and mother will be giving the services to the child for his or her proper upbringing. So it is a kind of the service from the side of the mother on behalf of the father, and therefore mother is entitled to some kind of the remuneration, and the remuneration will be given by the lawful guardian of the person as well as the property of the minor, and under Muslim law that is the father. Therefore, father, when the child is in the custody of the mother, maybe 5 years or maybe 7 years or maybe 9 years, as the case may be, for this period, whatever services are being given by the mother to the child in her custody, basically she is giving the services to the child of the guardian, because it is the responsibility of the guardian to make the necessary arrangement for the development, personality development of the child. And therefore, the mother who is the natural guardian but entitled to the custody, the mother who is not natural guardian but only entitled to the custody of the child, now she is entitled to some kind of the remuneration. And therefore, the parameter for deciding the remuneration for the mother for giving the services to the minor child when the child is in her custody, that is that at least mother should be paid to the extent of the half of the payment or remuneration which she is receiving from the father as maintenance. For example, W is a woman. Now, she was married with H. From H and W, a son is born S. When son is of 1 year, there is a dispute between the W and H, and pursuant to their mutual dispute, they have separated from each other by means of the divorce. Now, as per rules of the Muslim law in Syria, in Jordan, the women, that is the mother, will be entitled to the custody of the child up to 7 years because he is a male child. Now, when the child is in the custody of the mother, then for this period, for giving the services to the child, H is also required to reimburse the W for his service, her services. And what will be the reimbursement? Reimbursement is that after the separation, whatever amount of maintenance is paid by the husband to the divorcee W, half of the maintenance will be the charges for giving services for the custody of the child. Very good law. But in India, this type of the arrangement is not there. Mother feeds to the child even after separation, but she is paid only the maintenance charges, not the charges for giving the services to the child. And therefore, such type of the arrangement should also be made through the judicial decision in India. Now there is a country, Syria. In Syria also there is a law. The liability of payment of remuneration for custody is that a person who is responsible for maintenance of the minor. For maintenance of the minor, who is responsible? It is the father or lawful guardian. Therefore, remuneration for upbringing of the child will be given by the father, but the charges should not be more than half of the maintenance charges of the minor. For example, if the minor is on minor rupees 1,000 is spent, then rupees 5,000 should be given to the mother for uh, custody charge or as a custody charge. And in this way, ladies and gentlemen, different uh, rules of remuneration is provided. In India, the matters relating to the custody of minors are regulated substantially by personal law and partially by a Guardians and Ward Act 1890. Section 19 by Section 19 as well as Section 25B are the important ones. I have already pointed out that the father is the natural guardian of the minors and as such entitled to the custody of a son who attains the age of 7 years or more. A daughter who attains the puberty, making the termination of her mother's period of vision. Yet there may be very good reasons for denying him that custody, consistent with the demands of the welfare of the minor, which is over all determining factor to be kept in view. The paramount and determining consideration in all such cases is the welfare of minor, not the rights of the parents, in whose favor initial but rebuttable presumption can be raised. The nature and scope of the expression welfare used in section 25 has been interpreted and explained by the courts in the several cases. In Muhammad Ismail versus Noor Jahan, Allahabad High Court held that under Muslim law, the custody or hizanat of a minor child should be decided basically on the welfare and the best interest of the child. And even if it deviates from the traditional rules about who is entitled to the custody, for example, mother or father, but position of the parent should not be in consideration for deciding the custody. What should be the interest of the child, the welfare of the child, the well-being of the child, the future growth of the child, future personality development of the child, that should be the prime consideration while deciding the issue of custody and guardianship. Muhammad Siddiq Ali versus Nizam Nisa Begum. Privy Council held that the welfare of the minor supersedes the strict rule of custody in Muslim law. In this case, the court reiterated that the custody should not merely follow the default rules, but determined by what the serves the child's welfare. Sheikh Muhammad Safi versus Noor Nisa, Andhra Pradesh High Court held the mother was granted the custody of her minor daughter because the court found it to be in the child's best interest. Even though father had a legal right to the custody under Muslim law, but since the best interest of the child is protected under the care of the mother, therefore mother should be given the custody of the child. Musamma Zohra Begum versus Muhammad Ibrahim, Privy Council ruled that in custody dispute, Muslim personal law should align with the minor's welfare, and custody should be denied to a parent whose care is deemed to be detrimental to the future of the child. Shahid Khan versus Anjum Pasha is another important case. The petitioner, by this petition of habeas corpus, seeks the protection of his son stated to be aged over 7 years from the custody of his ex-wife, and her brother and mother implicated responded. It is the case of the petitioner himself that the child is in the custody of the mother at Hyderabad since May 2009. Court said, we are unable to agree and are unwilling to entertain this habeas corpus petition to adjudicate competing claims of the petitioner as well as father and the respondent as mother to the custody guardianship of minor son, and which adjudicates shall necessarily entail the question of certifying the best interest of the minor. Hence, the petition was dismissed. Uh, Asrar Ahmad versus Azharul Hussain, matrimonial relation between the appellant Asrar Ahmad and Srimati Zafran became strained. And on 26/4/2008, Srimati Zafrana left her matrimonial home. In view of the said factual background, the appellant Israr Ahmed filed a case bearing miscellaneous number itne itne before the principal judge Sitapur for custody of his minor, that is uh, the respondent number one Azharul Hussain on 77/8 uh, 2008, Principal Judge Family Court Sitapur dismissed the case of the appellant for custody of minor child, namely Azazul Hussain, and observed that under Muslim personal law, the mother is entitled to the custody of her male child until he has completed 7 years, and female child until she attains the puberty. Puberty is attained at the age of 14 or 15 years normally. If the minor is capable of making the preference, he should be brought to the court, and thereafter order of appointment of guardian should be appointed. In the instance case, the minor who is now aged about 10 years after 10 years ever since his birth is living with her mother, who is taking good care of him, though father may take still better care, coupled with the fact that he has appeared before the court and has clearly expressed his willingness to leave her mother. I am of the therefore court held that I am of the view that interest of the welfare of the child is with the mother, therefore mother should be given the custody of the child. In such circumstances, when the interest of the welfare of the minor is with the mother or personal right and under the Muslim law, which are only the guidelines. After considering the aforesaid, the court below came to the conclusion that looking into the welfare of the minor child, it would be appropriate that custody of minor should not be given to the appellant, and accordingly dismiss the claim of the appellant. Ladies and gentlemen, I have made the reference of several cases dealing with the custody or hizanat of the child as well as the guardians. And after detailed discussion on various aspects of the subject matter of the custody and guardianship, one will arrive on the conclusion that on one hand there are customary or respective personal laws dealing with the custody and guardianship of a minor child. On the other hand, there is a statutory law, that is the Guardians and Ward Act 1890, providing for the custody of minor children. Personal laws have laid emphasis that custody should be decided in the light of the respective personal law. However, under Muslim law also there are sources justifying that under all circumstances the rules of law will not be taken into consideration for, but some other factors, that is interest of the child, welfare of the child. Because if you go by the spirit of the subject, one will arrive on the that spirit of this topic, that is custody and guardianship, is to ensure that the interest of the child is not jeopardized because of the dispute between the parents or absence of one parent from the care and custody. Therefore, even under Muslim law also, normal rule is that in ordinary course of the circumstances, father is the guardian of the person and property, and mother is entitled to the custody of the child up to certain age, having regard to the sex of the child, gender of the child. But at the same time, Muslim law also support to the theory of the welfare and has established that if in given circumstance the parent who is in the custody of the child is not fulfilling his her obligation, and due to non-fulfillment of the obligation the interest of the child is jeopardized, is adversely suffering, then the child can be withdrawn from the custody of the custodial parent and can be handed over or can be given to the father who is non to the parent who is the non-custodial in the given circumstance. Reason is that it is the welfare of the child, it is the interest of the child which is supreme, not it is the right of the parents that is the supreme. Of course, one may be entitled, but if circumstances are disqualifying him, then he should be disqualified. But now the point is that everybody agrees that the prime consideration in deciding the custody issue should be the welfare of the child. And how the welfare of the child will be decided? The courts in different cases have laid down the criteria or indicators, parameters. And the basic parameter is that in whose care the indispensable right of the child are safe. For example, right to education, right to health, right to proper nurturing, to learn the arts and culture. So these are the parameters. If a child is deprived of his or her basic right, that is right to education, and right to education means the quality education, not only the formal education, quality education. Child should be assured the quality education. Under whose care the quality education can be ensured? Either father or mother. Father may be entitled or mother may be entitled to the custody of the child. But during the custody, who can be the best person to serve in a best way for the better future of the child? Basically, the law will prefer to him and he should. And therefore, a clear law should be enacted. Clear law should be enacted providing who shall be the lawful guardian of the person as well as the property, and Preference should be given while enacting the law that both the parents should be given the joint right of the custody and guardianship. Only the joint custody and guardianship will ensure the better future of the child. If joint guardianship is ignored, and in case of that, because if one, because here this is also a point of consideration. Let's say, for example, there is a dispute between the father and mother. Father is entitled to, is of course, is a guardian of the person and the property of the minor. After certain age, up to certain age, mother is. On the expiry of that very age, of course, the custody by law will go to the father. But now the decision are being given that if the father, the interest of the child under the care of the father or custody of the father is not going to be safe, then mother will. But and mother will take the child. In so many cases, the mother has been given the custody over the child, and the child is taken away by the mother. Now, father is living in one city, mother is living in another city, far away from the father. Now, mother is totally innocent. He is not knowing, she is not knowing what is going on, what has led to the separation between the father and mother. But because of the order of the court, for the child has gone with the mother, is living in the care under the care of the mother. Mother is also paying the full attention. She is taking all type of the care for the better future of the child. Her child may be happy, but sometime the child would remember his father also. Because this is the natural bond. Fathership is a bond. And that bond cannot be broken, cannot be disconnected by the circumstances. It is the circumstances that has forced the child to go with the mother and may be happy to some extent with the mother. But affection, he is going to be deprived during the stay with the mother of the affection of the father, which is very natural. And therefore, effort should be made by the law to bring the law for the joint guardianship. Because the joint guardianship is not going to do the justice between the parents, is not going to do the justice, are not going to ensure the justice between the uh, between the persons, husband and wife, but it is going to do the justice with the child himself, and therefore child should not be deprived of his right. With this, now I thank you all.